which is still subject to translation. And I would like to be a little cautious before I start going into details, which I'm sure we'll have shortly. It's in Gujarati. We believe that this is full of errors and legally unsustainable conclusions. But make no mistake, generally, all your attempts to create a chilling effect, a throttling effect, a strangulating effect on open, fearless speech relating to public interest will not stop either Rahul Gandhi or the Congress party. This particular speech was made in the context of price rise and unemployment, as the speech transcript shows. It was made in Kollar more than 3-4 years ago. And there are some disturbing aspects of this judgment, which of course shall be subject to challenge proximately and immediately, but which I want to share with you very briefly. Firstly, the heart of the law of defamation, criminal defamation, is that persons who are complainants should be those who must be able to demonstrate how they personally, A, B or C, is defamed. How is he or she prejudiced? Now the admitted position is that no one which is the subject matter of the statement which is found to be offending has filed a criminal complaint. The first condition precedent of the law of defamation appears to have been patently not fulfilled and yet led to a conviction. Secondly, it is equally well established that malice is an essential ingredient of such offences. The very context of this speech shows that there could not have been any malicious intent. A leader of the political party of India with a pan-India footprint was speaking about unemployment, price rise, in the course of which there is a sentence which has been found to be offending, less than a sentence. The focus of the speech was not these three persons. The intent of the speech was not these three persons. The thrust of the substance of the core of his speech was not these three persons. In less than half a sentence on a speech about public interest, political issues in the country, major economic issues like unemployment and price rise, social issues, there cannot be any possible malicious intent, which is again another vital condition precedent to make out the criminal defamation. And that is patently missing. Thirdly, friends, it appears, and I think we are right more or less, but again we will check up and revert to you, that after this complaint was filed and the magistrate who was at that time one Mr. X took up the matter, a large chunk of the time of the last 2-3 years was taken up by the complainant himself in going to a higher court and getting a stay of the entire proceedings, which is rather unusual for a complainant who should be interested in expedition. The same complainant, after a long period of time where he himself stayed his own complaint, suddenly withdrew the complaint, apparently after the magistrate, in respect of whom, before whom the matter had initially come, had ceased to hold office, and a different magistrate had taken office. It is that second person, Y, who appears to have passed this order of conviction. Fourthly, as we all know, this was an event in the course of a political speech completely dealing with various public interest issues in the state of Karnataka at Kollar. Without meaning to be technical, there is an established provision which has been expounded and elaborated by several Supreme Court judgments called Section 202, precisely created to prevent, without jurisdiction, mischievous prosecution complaints in areas where no cause of action has arisen. Clearly, a Kollar speech has no connection with Surat, although specious pleas can always be made that today in the internet world or a global village, the same statement goes everywhere. That certainly does not mean that 202 can be nullified by filing complaints in Kashmir and Sikkim for a speech in Kolar. Now the object of 202 is that the magistrate, before issuing process, namely before initiating process, must first examine whether reasonably it can be said that his jurisdiction has been rightly invoked. And he can simply reject the complaint saying, please go. He's not rejecting the complaint on merits. He can simply say, please go to the appropriate place, because I do not prima facie have any jurisdiction. The point of 202 was specifically taken. It does not appear to have been dealt with satisfactorily, and that would be another major issue in the appeal, which is immediately going to be filed. Another issue, as fifth issue or facet, is that very short arguments appear to have been heard on the issue of sentence, and somewhat near the maximum sentence appears to have been imposed after very short arguments. As you know, sentencing is a different, separate, distinct procedure which requires proper hearing and arguments apart from and irrespective of conviction. As I said, this government is clearly relying, if it is in parliament, one set of techniques to throttle voices. If it is outside parliament, a second set of tactics which in recent times has had an effect inside parliament. So you say something outside parliament and we won't allow parliament to run. The third strategy is to file false, frivolous and vexatious cases to throttle voices. No doubt there is a conviction, but this is an infirm, it's an erroneous and an unsustainable judgment. It will be challenged, and we are hopeful that it will be stayed and ultimately quashed. Thank you.
Haji, आपके सवाल. Haji.
सर, क्योंकि अब 2 साल क्या कन्विक्शन हुआ है, तो चर्चा इस बात को होने लगी है और काफ़ी ज़्यादा राइट विंगर जो है जगह-जगह पेंडिंग कर रहे हैं कि अब्दुल्ला आजम खान के मामले में जिस तरीके से तुरंत कार्रवाई हुई सदस्यता को लेकर, क्या वैसा होगा? हालांकि 2017 के ही एक एफिडेविट में सरकार ने कहा था कि लॉ मेकर्स को समय दिया जाना चाहिए कि वो अपने कन्विक्शन को चेंज।
मुझे कोई संदेह नहीं है कि जहाँ राहुल गांधी का नाम आएगा, यहाँ की सत्तारूढ़ सरकार वो सब कुछ करेगी जो अनैतिक है, बिना सिद्धांत के है और उस बात के भी विपरीत है जो उनका खुद का लिखित स्टैंड रहा है। मैं अपनी बात नहीं कर रहा हूँ कि आज अगर कन्विक्शन हुआ तो तुरंत 1 हफ्ता या 2 हफ्ता बिना दिए वो निलंबित होने की प्रक्रिया या डिस्क्वालीफाई होने की प्रक्रिया सही नहीं होगी, समय मिलना चाहिए। लेकिन हम आश्वस्त हैं और आप भी आश्वस्त रहें कि राहुल गांधी का नाम दिखते ही भय कह लीजिए, बौखलाहट कह लीजिए, ये सिद्धांत फॉलो नहीं किया जाएगा। लेकिन हम उन पर न निर्भर हैं न आश्रित हैं। इस कानून में जो किया जाए, इस निर्णय के विषय में जो चुनौती दी जाएगी वो ली जाएगी और हमें विश्वास है कि इसको स्टे किया जाएगा निकट भविष्य में।
Do you think, or rather I'm asking you, that is the speaker or the chair of Lok Sabha, of which Mr. Gandhi is a member, is he empowered to sort of short circuit this timeline?
No, let me correct you. 30 days of suspension of sentence does not have anything to do with the disqualification issue in law. The disqualification issue is dependent on stay of conviction, not of sentence. They are two different things. So that is a different proceeding. But yes, any reasonable system, any reasonable, fair, non-oppressive, non-biased system would give sufficient time to a person to take some legal steps to stay the conviction. But equally, having said that, I doubt very much if this government will act in any of those 4 adjectives: non-biased, fair, transparent or balanced.
एक मिनट शिकायतें आती हैं कि सिर्फ जो जवाब है वो सुनाई देता है, सवाल सुनाई नहीं दे रहे हैं, इसलिए हम आप सभी को माइक दे रहे हैं।
सर, आपने जिक्र किया, आपने पॉइंट किया कि जज पहले दूसरे थे, बाद में हाई कोर्ट में इस पे हुआ था, दूसरे जज आए और सजा का ऐलान किया। कोई नहीं आवाज आ रही। खड़के साहब ने भी इस बात का जिक्र किया जी ये कह रहे हैं कि कांग्रेस चाहती है कि न्यायपालिका को जेल में रख ले और वो सम्मान नहीं कर रही है न्यायपालिका।
ये आपका आखिरी वाक्य सुन के तो मुझे लगता है कि उल्टा चोर कोतवाल को डांटे। ये आपका आखिरी वाक्य आप वापस दोहराइए। पूरा देश जानता है कौन ये कर रहा है जो आपने वाक्य में बोला है अभी। और हमने तो एक तथ्य दिया है, आप एक कंप्लेंट फाइल करते हैं, आप खुद अपनी कंप्लेंट को जाके रुकवा देते हैं और अचानक उस रुकवाने वाली प्रक्रिया को विड्रॉ करके वापस कंप्लेंट को शुरू कर देते हैं। इसमें क्या है? ये तो तथ्य हुए ना। और जहाँ तक आपके वाक्य का सवाल है, ऐसे हमारे पास कई उदाहरण हैं। जो आप कह रहे हैं वो ये सत्तारूढ़ सरकार करती है।
13 clearly states that all convicted MLAs, MPs in a criminal case will be disqualified from holding their office from the day of conviction itself, even if the conviction is from a trial court. So does he stand disqualified right now?
Let me not get into that law, but let me assure you that as far as the government is concerned, Rahul Gandhi has sought to be de facto excluded from parliament already for last several days and weeks. What is the point of him going to parliament and speaking when he is not allowed to speak before a prior apology? And what is the point of supposedly talking of parliament when the government of the day itself is disrupting? So de facto there is no difference between him not speaking in parliament and not formally entering parliament. However, these are legal issues. The judgment has come today. Obviously, some time has to be given to a person to challenge it, and we are confident that it will be stayed. The conviction will be stayed.
सर मेरा सवाल ये है कि फैसला कोर्ट का है और फिर आप कोर्ट में ही चुनौती देने जा रहे हैं इस मामले को, लेकिन कोर्ट पर जब आपको भरोसा ही नहीं है तो फिर चुनौती क्यों देने जाएंगे आप?
हमने कोर्ट पे भरोसा की बात ही नहीं की। न्याय व्यवस्था में पूरा भरोसा है, न्यायपालिका में पूरा भरोसा है। एक इंडिविजुअल स्पष्ट निर्णय में हम गलत मान सकते हैं, इसमें कोई विरोधाभास का सवाल नहीं उठता कि एक निर्णय जो है वो गलत है और साथ साथ न्यायपालिका में अपने ही न्यायपालिका वाले ढांचे में वो सब विधि विधान हैं जिसके द्वारा एक गलत निर्णय को सही किया जा सकता है। इनबिल्ट करेक्टिव सिस्टम एग्जिस्ट इन द जुडिशियल सिस्टम, एंड सर्टेनली वी आर एंटाइटल्ड टू इन्वोक आवर अपेलेट राइट्स, एंड सर्टेनली वी आर एंटाइटल्ड टू से लुक दिस जजमेंट इज रॉन्ग and this judgment will be corrected. Do you know that the same High Court, in almost 75% High Courts, has a procedure whereby the same judges who sit at lunch together, which the Chief Justice also spoke at a recent conclave, which we know for decades. So he sits as a learned single judge and his colleague judges sit as a division bench and reverse him. This happens all the time.
नहीं आप YouTube के लिए आप सुनाई देते हैं।
सर ये अभिषेक सर ने तो बताया कि आपके पास रेमेडी लीगल क्या है, पॉलिटिकल रेमेडी कांग्रेस किस तरीके से लेगी, क्योंकि इस जजमेंट के आने के बाद में, इस सज़ा के होने के बाद में बीजेपी प्रेस कॉन्फ्रेंस करती है। अभी एक साथी ने सवाल पूछा, वो भी पीयूष गोयल जो सदन के नेता है वो ये कहते हैं कि लगातार जब राहुल गांधी बोलते हैं इसी तरीके से डिफेम करते हैं, उन्हें देश से माफ़ी मांगनी चाहिए। तो पूरा मोर्चा बीजेपी ने खोला हुआ है, हालांकि कुछ आपके एलायंस नए आपके साथ आके खड़े हुए हैं, लेकिन कांग्रेस इसको पॉलिटिकली कैसे लड़ेगी और अब जनता के बीच में जाके आप लोग कैसे इस बात को जो है स्पष्ट करेंगे?
देखिए, पीयूष गोयल जी और बीजेपी चाहते हैं कि ये इन प्रकारेण ये सदन नहीं चले। कोई भी कारण मिले तो एक प्री कंडीशन पहले डाल दीजिए, जिसके बाद आप राहुल गांधी का जो अधिकार क्षेत्र है पार्लियामेंट में बोलने का, उसको अलाउ करेंगे। ये कभी आपने सुना है ऐसी बात? ये वाहियात बात नहीं है कि जब तक आप एक्स नहीं करेंगे तब तक हम आपको पार्लियामेंट में नहीं बोलने देंगे। तो ये अपने आप ही में ये राजनीतिक जवाब है। हम झुकेंगे नहीं, हम डरेंगे नहीं, हम बोलते रहेंगे, राजनीतिक जवाब है आपके समक्ष। और साथ साथ अपने कानूनी रेमेडीज़ लेंगे। मैं समझता हूँ पूरा देश देख रहा है कि अब वो एक और अपॉलॉजी चाहते हैं और उस अपॉलॉजी के पहले आप संसद में बोल नहीं सकते, तो आप अपॉलॉजी मांगते रहिए।
Does the speaker have any discretionary power in this, in disqualifying the MP?
The answer in law is no if ultimately there is no stay of conviction.
Yes, Aditi, Ramana.
Abhishek ji, there's a parallel case on the same issue in the Patna, one of the Patna courts, where the complainant is BJP MP Mr. Sushil Modi. He has made a statement to that effect. I just want to understand from you, will that be a parallel judgment, or both the cases can be combined, or will Mr. Gandhi, just in case there is another order against him, have to stand trial separately there for the same issue?
No, we are talking of a judgment which has come today. Any other case has no relevance till a judgment